Good afternoon, everybody. My name is Adam Van Susteren, and I'm the president of the Lawyers Chapter of the Federal Society for San Diego. It's a group of conservative and libertarian law students, lawyers, and judges who bring debates to legal issues. Today we have a panel discussion on ethics and transparency in California's legal system. The panel will explore ethics in California's legal system, including the proposed conduct for attorneys general and transparency of relationships between elected officials, outside counsel, and judges. I would like to thank the Cal West student president, John Rogitz, for helping establish us here at the law school today. I'd also like to thank Aaron Dunley and Emily Johnson from the American Tort Reform Association for putting together this wonderful panel. Detailed bios and some of the panelists' writings can be found in the written material packet that was outside. So don't let a short introduction lessen the great accomplishments and intellectual heft of this panel. We have attorney John Coupal, who's the president of the Howard Jarvis Taxpayers Association. We have attorney Peter Scheer, who's the executive director of the California First Amendment Coalition. We have advocate Lorie Zapf, who's the president of the San Diego Citizens Against Lawsuit Abuse. Attorney Bob Gaglione, who's the principal of the Gaglione Law Group and the host of the Independent Counsel radio show. And we have a moderator who has served as an executive, a legislator, and a judge, Judge Jan Goldsmith.
Okay, it's a pleasure to be with you. I see out there some students. Any former students of mine? Okay, good. You're all A students then. Let me just say, we have a terrific panel and a very timely topic. This panel is going to explore the changing role of the Attorney General. Now, let me just read off some names to you as to who has served as Attorney General in the state of California. Ulysses S. Webb. All right. Anybody heard of him? Well, he served for 37 years as the Attorney General. He never went to a different office. Earl Warren, we've all heard of him, Chief Justice of the United States Supreme Court. Pat Brown went on to be Governor of California. Stanley Mosk went on to become a Justice of the California Supreme Court. Dan Lundgren became a congressman, had been a congressman before. George Deukmejian became governor of the state of California, and of course Jerry Brown has been Secretary of State, governor, mayor, and now is the Attorney General. It's a very colorful history of the Attorney General's office, and it has changed. And this panel will discuss that change. No longer just the lawyer for the state. Many attorney generals, not only in California but elsewhere, have initiated litigation aimed at regulating conduct and establishing public policy functions that have been traditionally, and in fact in some cases, in all cases, constitutionally left to the legislature. It raises some very interesting questions that we need to look at from a legal standpoint. My role is as moderator, and I'm looking forward to hearing from these folks. My brief introduction is over, and what I'm going to do is ask some questions of the panel members to stimulate a discussion. I have told them that they can say nice question and ignore it if they'd like, because I want to hear what they have to say rather than me just keeping them structured. We can interject some questions. I'll try to stimulate the discussion, but they can also discuss among each other. We are blessed with the great thinkers on this subject, and let's let them do it. At the end, we will have questions. We will also have some members of the Attorney General's office. Do we have members of the Attorney General's office here? Okay. We're going to hear from them on some thoughts, and then questions from the audience. So we're going to begin with Bob Gaglione, who has done a terrific white paper on this subject, which I enjoyed reading. Okay. Bob, what is the proper role of the State Attorney General, and how has it changed?
Thank you, Your Honor. That is a very nice question, and I will answer it. While this program is about ethics and transparency in California's legal system, I'm going to focus my remarks, as you know, specifically on the State Attorney Generals. And as Judge Goldsmith told you, the white paper that I helped write, The Modern Role of State Attorneys General and Renewed Activism, is included in your written materials. Something that is gaining and maintaining popularity in state attorney general community is the retention of outside or private counsel, oftentimes on a contingency fee basis, which raises a whole host of concerns, which will undoubtedly be the subject of a number of our speakers today. Discussing first the traditional role of the state attorneys general, I'll point out that the very first recorded establishment of a state attorney general in the United States dates back prior to the Declaration of Independence. In 1643, Richard Lee was appointed as the Attorney General in Virginia. While the state attorney general was typically appointed in the past, today 43 states elect their attorney general. Overall, there are 56 attorney generals in the 50 states and territories of the United States. The traditional duties of the state attorney general include representing the state and its agencies in trial and appellate litigation, investigating individual corporate and government misconduct, and issuing advisory opinions on questions and issues of state law. State attorney generals are the chief legal officers of their jurisdictions and are oftentimes referred to as defenders of their state constitution. However, the popular phrase top cop is really a misnomer, as many state attorney generals actually have limited authority to initiate criminal prosecutions. Most state attorney generals are responsible for upholding criminal convictions in appellate proceedings, and among the most high-profile cases in states with the death penalty are, of course, appeals of convictions with a death sentence and associated habeas corpus proceedings. The California Department of Justice website discusses some historical perspective of the role of the Attorney General in our Golden State. In California, the Office of Attorney General was established in 1850 to contend with what was considered at the time an unstructured, inadequate, and inconsistent system of law enforcement. Since its creation, the Office of the California Attorney General has changed by three distinct forces. Number one, the California Constitution and state government codes, which specify the duties and responsibilities of the Attorney General. Two, legislative decree altering the duties of the Attorney General in response to specific state needs. And three, the personalities and ambitions of those who have served as the state Attorney General. The Office of Attorney General in its present form is vastly different from the office created by California's founders. Its development essentially mirrors the history of California and the development of the state itself. Gradually, through cases centered on the protection of state lands and resources, by monitoring corporate practices, through asserting the rights of people against discrimination, and by assuming the role of the state's central law enforcement authority, the Attorney General has grown to play an expansive and enduring role in the life of all Californians. It is the role of monitoring corporate practices in California and in other states which has created much controversy and caused the debate over the role of state attorney generals. The California Department of Justice website notes that it is the duty of the Attorney General to see that the laws of the state are uniformly and adequately enforced in accordance with Article 5, Section 13 of the California Constitution. The State Attorney General carries out responsibilities of the office through the California Department of Justice. The California AG represents the people of the state in civil and criminal matters before trial, appellate, and the Supreme Courts of both California and the United States. The Attorney General also serves as legal counsel to state officials and in most cases to state agencies, boards, and commissions. Exceptions to the centralized legal work done on behalf of the state can be found in Section 11,041 of the California Government Code. The California Attorney General also assists local law enforcement, district attorneys, and federal and international criminal justice agencies in the administration of justice. To support California's law enforcement community, the State Attorney General coordinates statewide narcotics enforcement efforts, participates in criminal investigations, and provides forensic science services, identification and information services, as well as telecommunication support. In addition, the Attorney General establishes and operates projects and programs to protect Californians from fraudulent, unfair, and illegal activities that victimize consumers or threaten public safety, and enforces the laws designed to safeguard the environment and natural resources. Under the California Constitution, the Attorney General is elected to a 4-year term in the same statewide election as the Governor, Lieutenant Governor, Secretary of State, Controller, Treasurer, and Insurance Commissioner. In 1990, voters imposed a limit of 2 terms on these statewide offices in California. California Department of Justice operates statewide with offices in Sacramento, San Francisco, Oakland, Fresno, and San Diego.